courts. And so I thank you all, the panelists, and I will now. So this event is scheduled to be for 90 minutes. We already are 13 minutes gone. Um, the panel discussion will be for 60 minutes, after which audience questions will be taken. So I would urge for any questions to be popped into the chat uh, area, and I will collate them and present them to the speakers after the panel discussion is over. So I will now hand over to Mr. Asia to take the panel discussion with the panelists. And thank you very much. You didn't come to listen to me.
Thank you, Shiu. Good afternoon, everyone. Good afternoon, Honorable Justice Boya, very distinguished Justice of the National Industrial Court, and Professor Kalula, the chairperson of the ILO Committee on Freedom of Association. It's an honor to be moderating this webinar on the implementation and compliance mechanisms for ILO conventions to focus on the African perspective. The traditional mechanism for compliance with ILO conventions by states is typically ratification, which signals the commitment to international labor standards. However, many African countries, other countries, have either not ratified key conventions or face significant hurdles in aligning their local legislation with these standards. Furthermore, the ILO compliance mechanisms also appear to be largely, not sanction-based, which raises concerns about the effectiveness of these conventions in shaping labor standards globally. And this also now give rise to the need for serious legislative and judicial interventions in various countries to ensure that the gap is bridged. And a notable example is what we have currently in Nigeria, where the National Industrial Court, has been given serious powers by the Constitution to arguably apply ILO conventions beyond the traditional requirement of ratification. This development is highly significant in discussing African perspectives on ILO compliance, as it offers an alternative model for ensuring labor standards are upheld despite legislative and political challenges in various countries. So I look forward to having an engaging discussion with our distinguished panelists. Now, Honorable Justice Boya, many of us in the employment space in Nigeria look to my law's judgment for guidance on international labor practices and standards, as now, which is now being enforced by the National Industrial Court in Nigeria. And of course, the distinguished chairperson of the ILO Committee on Freedom of Association, Professor Kalula. Because of time, I'll just go straight to the panel discussions with the various questions. The panelists, of course, have they're within their rights to reframe these questions in order to give proper perspective to the issues that is thought to be raised by the question. So I'll go straight to Professor Kalula. It will appear that technical assistance is the major way by which the ILO seeks to get African countries and some other countries to implement the ILO conventions, even when they have ratified. I would like to know how successful has this approach been in view of the fact that there appears to be no clear sanctions for failure to apply or implement ratified conventions. Professor Carola, can you hear me?
Unmute. Hello, can you hear me now?
Yes, we can hear you now. We can hear you now,
Yeah,
sir.
good afternoon. Thank you very much, Program Director. I think that's is that the title you use? It's really a pleasure to be with you and to join the webinar. First of all, let me thank the hosts, the Iran, and of course the Africa Labor Law Society for putting on this series of conversations that I think are enlightening. And I would also like to recognize, of course, my fellow panelist, the Honorable Justice Wana. Welcome, sir. I sort of, in my past life, I've not always been very popular with labor courts. I'll tell you more about that. But now I think we are quite we are friends, and the critical role you play in developing not only the jurisprudence, but much more importantly, and this is part of the the objective of this web seminar is to implement and encourage compliance. So I'm very, very grateful as a fellow traveler to labor courts. And of course, I think did I mention, has Claire already gone? Claire, are you there? She's probably left us. Claire, as the barrister staffer knows, is the engine of the Africa Law Society in terms of what in the UK called the GAFA, you know, the person who puts it all together. So I'm a regular guest of the society, so I'm always very, very grateful. Barrister Mustafa, I don't know what your titles are in Nigeria, but here you have stuck. I see you have stuck to the original, of the titles, the division between barrister and solicitor. The South Africans still have that, but they have advocate and attorney, whereas a lot of other countries in common law Africa have actually combined it to advocate. So it doesn't, so advocate, I'll use advocate, I think, as the title I know best. That's the title that is used in Zambia, Tanzania, Kenya, and Zimbabwe. A lot of actually Anglo common law countries. And on that jurisdictional issue, that's just very, very quickly in passing, I think it's worth noting that a lot of Anglophone Africa is common law in terms of jurisdictions. South Africa, Zimbabwe, Botswana, Lesotho, Eswatini, and the only other country, Sri Lanka, are based on Roman Dutch law. I'm talking about the previous British colonies and sort of colonial territories, so to speak. Please, Program Director, allow me, before I answer that question, to put things into context. I think it's useful to say one or two things about the ILO as an organization and why we are talking about these conventions. The ILO, dear participants, was born out of conflict. 1919, the world wanted to say never again, that we shouldn't go through, the world should not go through the kind of conflict that has been so destructive. So they got together in Versailles to focus on how to avoid further conflict and then have a lasting peace. And the ILO was part of that dream. And in fact, as a matter of emphasis, the constitution of the ILO was actually a treaty of the, was an article in the Treaty of Versailles. Of course, it has been amended over the years, but that was the emphasis. The basis of that, the rationale was that Germany, of course, would not have resorted so readily resorted to law if it had social justice. Social justice, therefore, is the central pillar of the ILO's mandate. The belief that if you have got social justice, not only in the labor market, but in other areas of national endeavor, you avoid this kind of conflict. Of course, that dream was shattered because years later, 1939, another world war broke out. But thanks to the founding fathers, they were all men. The ILO survived that conflict. And in fact, went on in 1946 to become the UN's first specialized agencies. I need not go into what a specialized agency and so forth. So I think it's important to understand that the ILO mandate is one of social justice. It's one that arose out of conflict. And 100 years later, conflicts have not gone away, as we know. Not only elsewhere in not only in Africa, where we are very familiar, unfortunately, with continuing conflicts, national and across border, but also internationally. So, but the dream, so to speak, lives on. That social justice is an important pillar of development when we are talking of Africa. And then where you have social justice, the chances are that you are going to minimize unnecessary conflict. That rationale still holds. And it still holds, by the way, and I don't know, Advocate Mustafa, whether you are going to share with the participants my PowerPoints. I have indicated there that this dream of a social just world still holds in spite of the continuing conflict. And it is important, I think, to underline that dream 100 years ago, the world was very different. And I'm going to say something about that when I come to, to say, to comment on the Committee on Freedom of Association. The world has changed. We now live in what people refer to as a perpetual polycrisis, global polycrisis, not only in the social sector, but in all sectors of life. Inequality has increased, poverty goes on, and pandemics, of course, don't help it. So that's where we are. I thought I should put that in context. Now, coming to the question, Program Director, how effective is the technical assistance? Technical assistance, which incidentally is within the gift of my committee. When I say my committee, the Committee on Freedom of Association, is seen as an important tool to enable countries to be able to respond and comply, and this is the heart of our conversation, and implement international labor standards. We'll see later on, I think the judge is going probably to speak to this at some point. We'll see what barriers stand in between the implementation and compliance with international labor standards. Many of them relate to capacity. And technical assistance is seen as a way of removing some of those barriers. Of course, there are other factors that affect the implementation of and compliance with international labor standards, but capacity is one of them. Of course, there is political willingness when all is said and done, there's that as well. But in Africa, dare I say, at least in Anglophone Africa, there is much more of a willingness politically to implement and comply with these international labor standards. So technical assistance, to come back to your question, is a way of doing that. What examples are there? There are many examples, including Nigeria. Your latest reformed law, which a colleague of mine at the University of Cape Town, Hatton Chido, spearheaded, was an example of the intervention, technical assistance intervention. There have been other examples all over Africa. If you take Anglophone Africa, there have been interventions in Tanzania, there have been interventions in Zanzibar, there have been interventions in Kenya, and many other countries. And for my sins, I've been involved in some of those. In particular, and I'll come back to this, in particular with what I regard as probably the most effective intervention of technical assistance, that of the former Swaziland, now Eswatini. At some point, I'll come back to that just to share that experience and how I think technical assistance has helped those many countries in Africa, including Nigeria, not to mention South Africa itself. The outcome of what we have here now was due to ILO intervention. Thank you. I'll leave it there for now. Thank you. The second question is to me as well. Do you want me to proceed or I should pause there? Please. Dr. Asia. You are muted. Do you want me to proceed?
Prof, I mean, because of time, you can just proceed to the second question.
Yeah,
so
okay.
We can then move
okay,
to,
thanks. The second question relates to whether the ILO collaborates with regional organizations such as the Africa Union, the Regional Economic Communities, ECOWAS, SADC, East African Community, to assist in implementing their commitments and improving them. Yes, it does. And the clearest example of that collaboration is for the English-speaking countries is ALAC. ALAC is the Africa Regional Labor Administration, commission that is based in Harare. That is a setup purposely established to foster collaboration between the ILO and the African countries. Similarly, of course, they do have, the ILO does have collaboration with regional organizations, SADC for that matter, to mention an example, East African Commission as well. And I'm not sure about ECOWAS, but I suspect, and the judge, I think, will probably highlight that. So yes, it does collaborate with other regional and sub-regional organizations with the purpose of fostering and enhancing the implementation of ILO standards. Thank you.
Thank you, Prof. Thank you for that very interesting discussion on the two questions. You have told us that social justice is at the heart of ILO conventions, and that in ensuring compliance and implementation, technical assistance is very paramount because of lack of capacity for many countries, including countries in the Africa region. And he also pointed the fact that technical capacity was given to Nigeria, even in coming up with the current legal framework that has revolutionized legal laws in Nigeria. Let's now move on to my Lord Honorable Justice Ogboanye. My Lord, some African countries, particularly like Nigeria, have amended their laws to allow direct application of ILO conventions. But questions remain about the extent, the application of these conventions, and this can be seen from various decisions that we read on a daily basis from the National Industrial Court. Do we consider this approach to this, or are there better models or other examples that Nigeria could have adopted to properly apply ILO convention?
Thank you, Elvis. Let me thank and welcome Professor Kalula for that wonderful insight. Yeah, when it comes to ILO and Nigeria particularly, and other approaches Africans are using, the most important part of it is that the laws are actually brought into local application. So because of the nature of international law, that it does not have a direct local application until further legislative intervention at the local level. That is where this dichotomy is coming from. But before we go there, you have to understand exactly the nature of convention and protocols and recommendations of the ILO. Actually, is made from the three groups, that the government, employers, and workers. And is actually, like Prof rightly said, focusing right now on social justice, decent work, and ensuring that the rights at work, the principles and rights at work are really articulated. So it's not one person or one side affair, contrary to what they see us from the judicial point. Although labor itself originated from, like Prof rightly pointed out, trying to migrate the interest of the people to a point when the labor will be recognized and will not be oppressed by the capitalist bourgeois. So for now, the labor is balancing. Labor jurisprudence is balancing the rights of workers and the rights of the labor, the rights of the employers, the rights of governments. All parties are actually there because that's the real foundation of the convention. So they're not made by one group. So every international labor standard that resulted in legal instruments were actually done by this ILO constituents. That's the government, the employers, and the workers. And then the convention itself are the ones that are binding. That's like international treaties and maybe ratified by states. While the recommendations are not generally non-binding, but serve as a guide. They try to amplify the conventions, though they can still stand alone. Then the real point is that once it is done, like a convention, is a standard is adopted by this tripartite agreement by the ILO constituents. Once that is done, the next stage is implementation. And the first line of implementation is the ratification. So when you ratify, it means you have signed into it. And when you sign into it, then within 1 year, a period of 12 months of that ratification is really deemed to come into effect. So it's now automatic effect upon ratification. That is the way the legal structure is made for ILO conventions to operate in different member countries. So the problem here is that in some countries, the issue of direct and automatic coming into force upon ratification within 12 months does not happen as envisaged by law, by the ILO Convention under Section 19.6 of the Constitution of ILO. So that was what was envisaged, that after 12 months of ratification, that convention comes into the country automatically. But then, if you look at the Nigerian scenario, under Section 12 of the Nigerian Constitution, It does not happen. That provision of the Constitution actually, removed the effect of that automatic coming into force by saying that that international laws or the protocols or conventions ratified by Nigeria can only come to take effect applied fully when Nigeria had domesticated the law. That means by Parliament passing a local law, accepting it again. That's another layer of application standard. But then there's this situation that also happened in the Constitution, whereby Section 2542 of the 1999 Constitution amended the Third Alteration Act, which is established industrial court, says return back to the normal ILO standard by saying once Nigeria ratifies any of the ILO conventions, it does not require further domestication. So it appears that there is a direct conflict with the provision of Section 12 and Section 254C, 12C2 of the Constitution. But then that was one of the opportunities I had in the course of this duty as a judge to address that issue very well. And I'm sure many of you are aware of that case involving Joseph Osayede against Shell Petroleum Development Company Limited. I could share it to you later if you need copies to read in detail. But that suit, the suit number NICS/YEN 48 2018, judgment was delivered on April 20, 2023. That was the first attempt to see how to resolve this seeming conflict between Section 12 of the Constitution and Section 254C2 concerning acceptance and application of labor standards that were not fully ratified or fully domesticated in Nigeria. So, for instance, in that case, there was a dispute concerning implementation of the Convention on Termination of Employment, C-18. Then the argument was that it is not, Nigeria did not domesticate it. Nigeria did not even ratify it. So where is it going to come into play? But then Section 254C2 1F and H authorize industrial court to apply national best practice in our fair labor practice. So this gave the NIC right and duty to go into further analyzing of the jurisprudence of ILO with service local legislation. And in that case, I try to reconcile the position by saying that the two provisions are not inconsistent. First, Section 12 dealt with general laws, general international law, conventions signed in different areas of law. But Section 254C2 was specific on the ones relating to labor and employment, such as the ones emanating from ILO. In that case, I resolved that there was no conflict, but rather it is complementary. So the best which we have found following this judgment is that both the local domestication is not necessary for enforcement of ILO conventions in Nigeria, first for those that were ratified. And those that were not ratified, you can draw the principles inside those ones and use the principles as international best standard, best practice to benchmark the lower standard or the minimum standard required. For instance, when you are testing unfair labor practice, you have to look at what is the standard on the convention that is not even ratified by Nigeria. For instance, C180 concerning giving reason for termination of employment. In Nigeria, there is dichotomy between statutory employment and master servant, where we are saying that, oh, master don't have to give reason to sack an employee. But then the argument has been that since there's a convention of ILO dealing with giving reason for termination, then that means that a court can now drop the principles without even citing it as if it's directly applicable, but can draw the principles and say, oh, we see that this is the best practice. This is international best practice that is now allowed by in the Constitution by Section 254C1, H, and F. And to say hold otherwise means promoting unfair labor practice. Why will you just put somebody without even telling the person what they have done wrong, and just say we have terminated with immediate effect, without minding the input you had made, without minding the number of years put in the system, without minding other factors that surround the employment, knowing that the employment is like psychological. So if you just terminate the person, not about the money the person is earning the month, but even how the person will go home happily and how you will feel among peers. So this is where social justice issues are coming in. That you don't just terminate someone's employment in because the person had fixed psychological effect, and the relationship are built within this organization. So what is missing is not just the work; it's missing the relationship built over the years, the impact they had had on him, and even within the society where he's operating. So you need to do that in a guided form so that the person can still go, but not going in a form that will disparage the person and not give room for decent work. The decent work encourages that when you are working, you also go decently. So that's why that principle was being adopted in the court. And I had the privilege of sitting on that judgment and took my time to write elaborately using a lot of jurisprudential argument to show that this is what we should be encouraging, because the Constitution had given National Industrial Court the leeway to apply international best practice. And that international best practice need not be a codified law. It may be a law like common law, which are based on principles. And those principles could be adopted without minding where they're coming from. So the important thing is that unfair labor practice does not encourage social justice. And therefore, if you practice unfair labor practice and allow it into your domain, it means you are discouraging people from embracing the reality of social justice. Otherwise, what is the concept of social justice? Social justice is being able to introduce into the legal system its fairness in a robust manner, in a practical approach. So here we're talking about practical approach. So Nigeria had done its best by first enacting that provision in the Constitution, which removes the idea of speculating on whether ILO convention is capable of being introduced in the country or not. So I think that is one of the very serious intervention of the legislature in Nigeria concerning implementation of ILO. So, and that, as we go further, you show that it has saved Nigeria so many problems in terms of reporting, in terms of queries from ILO, amidst most of other things that were saved by mere establishing industrial court, giving it such powers. So it eventually become the reporting and implementing forum for ILO. So most decision coming from the court is viewed from this is Nigeria, what Nigeria is doing about it. So it's no longer about a measured approach to ILO implementation. Thank you very much. Hello?
Hello? Program director, you are muted. Can I come in? Can I come in and follow his lordship? In terms of the question here is to both of us. Some African countries.
Sorry, Bob, can you hear me now?
Yes, I can hear you now. I'm just following up on his lordship. Is very clear and sort of remarkable explanation, which really is enlightening in terms of the role of the courts. I said at the start, your lordship, that I've not always been a friend of the labor courts, and I'll tell you further down. But your example, sort of makes me eat my words, because it's exactly the role that the labor courts should play. And my quarrel was here with the labor court, with my old friend, the former Chief Justice, and now who was at that time the judge president. So in my inaugural, I took issue with the way the labor courts were not really playing what I thought should be an effective role to play. So coming back to this, his lordship has indicated particularly in the context of Nigeria, one of the major barriers of implementing ILO conventions. That's the law itself in terms of not talking to each other, and then that conflict. And I should commend Nigeria that in spite of your problems in implementing that I think you have as a country, like many countries, the decision to directly apply international labor standards is a good one. Many countries don't have that system. So what happens is that when ILO conventions are adopted, they are more or less adopted by government and not the state, but not sort of can be directly implemented. So the local legislature has still got to approve that ratification, which is a situation I think that his lordship was trying to address. That here you have got a state. They are obliged, as a matter of international law, once they have ratified, to apply that. But their hands are bound as government because the legislature is the ultimate authority. So you have that division one. Now, what does that mean in terms of the other barriers? The other barriers, as I said, that's the start, their capacity. A lot of our governments don't have the capacity. First of all, the demands of reporting and compliance are quite heavy. In terms of you need a staff that is going to follow up and file reports with the ILO, the International Labour Office. You need to have the technical capacity to be able to follow up, particularly now in areas of health and safety, and report on that. But there's also the issue of political willingness. In spite of, and we are, as citizens all over Africa, we are very familiar to what our governments undertake to do and what they don't do. And that is usually not so much that even in instances where there may be no technical barriers, it's a question of political willingness. You say one thing and you don't do it. So those are some of the factors. What can be done to improve compliance? Of course, His Lordship, as he pointed to some of that, courts can play a role in terms of ensuring that there are these follow-ups, that through jurisprudence, the standards are applied, because essentially the standards speak, the conventions speak to the law, and that law is domestic law. And judges have the capacity and, of course, the independence, which is critical in terms of as a third arm of government, to indicate by case law, by decisions, that this should have been applied. That, as His Lordship said, that where a dismissal is unfair, the court can undo that. So that's one way of enhancing it. And of course, as I keep saying, enhancing capacity of the civil servants through training, and there again you link it to technical intervention. The ILO through the sub-regional offices, regional offices, do have in fact a lot of capacity to train that. And when I speak, Your Lordship, when I speak to African governments in Geneva, as I usually do after every session, I say to them that, look, the gift of capacity does not lie with Caesar. It's in the region. Every office there, you see those ILO diplomats running around. They are ILO specialists. And governments ought to take advantage of those. But much more so, and this is, I'm not very popular by reminding African governments about this, much more so, the use of their own citizens, specialists. More often than not, what will happen, and it's in every country, whenever a country wants intervention, ILO intervention, they will run to the ILO, and what will the ILO do? They will bring a specialist from Europe. They ignore completely their local expertise, who are not only expert and specialized in those particular areas, but they also have the advantage of being on the ground and knowing the context and the root causes of what they are doing there. Okay, we won't pretend that in every country, Nigeria might, South Africa might. Every country may not have that capacity, but why not team up those experts? If they are bringing in any special knowledge, at least let them have stagiaires to oversee. And normally, these ILO consultants that are thrown in, they are paid so well. And within the budgets that are given to countries, it's enough to have what in effect are peanuts for local consultants. I don't have a chance now as much to do any consultancies, but whenever with a chance, I insist that there must be a local counterpart, capacity building, but also taking advantage of the local knowledge. So these are ways in which the implementation of standards can be enhanced. Thank you.
Thank you, Professor Kalula. I apologize. I had network issues when my Lord finished his presentation on the last question, which was quite remarkable. The Sayanda case that my Lord referenced has become a seminal judgment on the issue, except that I'm sure the audience would maybe the opportunity to ask the question, because people still ask questions why there are so many conflicting decisions of the courts in that regard. Thank you, Prof, for the enlightenment on the steps that on how we can solve all the key barriers to implementation, particularly in Africa. I'd like to move on now to the supervisory mechanisms for ILO conventions. The Committee of Experts on the application of convention recommendations play a very crucial role in compliance. They make recommendations which explains any gray area in ILO conventions and guides the various states that are signatory to the convention. The question is, how does this committee function? And most importantly, how does the court, particularly the National Industrial Court, where my Lord Justice Boya is doing very well, how does the court rely on these recommendations? We have seen decisions of the NIC where courts will want to apply even the recommendations, not even the convention itself. So the question is, to what extent does the court have the powers to rely on these recommendations from the Committee of Experts in forcing ILO conventions in our courts? I think I'll just move straight to my Lord Honorable Justice Ogbanya to answer the question, since my professor has already given a good expose on the key barriers to implementation of the convention.
I think his lordship is muted. Program director, if you can indulge me, please. And it's important because essentially this section is looking at the supervisory mechanisms. I just want, before his lordship comes in, I just wanted to say very quickly a word or two about the supervisory mechanism, which is crucial
please
and
go
ties to, as a means of implementation. Basically,
go ahead,
can I go ahead, Program Director?
Go ahead, sir.
Thank you. Yeah, the ILO system of supervision essentially consists of three structures. The first structure, which has been I think in existence for longest, is the Committee of Experts on the Application of Conventions and Recommendations. That is an independent committee consisting now, I think there are about 30 experts, and these are usually former judges like His Lordship, the former judges of the ICJ, and the professors of labor law that have pretensions of expertise in labor law. It's an independent body. And its role is to review legislation of countries in terms of the conventions they have ratified. So, but that is staggered. It's staggered at the moment. I think it's every 2 years. They will pick up, they have got a schedule of which conventions they are going to review. And now and again, they will pick on an area and do a survey, a world survey, to find out how that particular area is doing. That's the first body. The second body is what you might call is the committee, and incidentally, the Committee of Experts is independent but reports to the second body, which is the Committee on the Application of Standards. And this is a committee of the war, if you like. It's a committee of the International Labour Conference, the plenary of the ILO. Because remember, the ILO has got three arms. It's got the GB, the governing body, which is the executive. It's got the International Labour Conference, which, for lack of a better term, is the legislative arm of the organization. And then it's got the office, which is the secretariat. So the second body, the Committee on the Application of Standards, which is an International Labour Conference body, also monitors the application. And that's when we come, I think His Lordship might speak to that, when we come to sanctions, that is in fact the body that dishes out sanctions as they are. And then the third one, which is a committee of the governing body and reports the governing body, it gives its report to CAS, the Committee on the Application of Standards, for information only, but it reports directly to the governing body with recommendations, is the Committee on Freedom of Association. And this is a tripartite committee. I think His Lordship mentioned this unique character of the ILO, that governments, have partners, social partners that they've got to deal with. And the Committee on Freedom of Association is tripartite, consisting of three constituencies: governments, employers, and workers. 18 of them. I'm the independent chair. And my role, which is a role I love, and I wish I'd done this most of my life, but I wouldn't have been able to. I would not have been ready to do it. It's very exhausting grown-up work. Is the one that considers complaints from mainly workers' organizations, but also employers. So those are the three supervisory systems that oversee the implementation and application of international labor standards. I'm sorry if I've taken too much time from His Lordship. Thank you.
Thank you, Bob.
Hello?
Yeah, we can hear you, sir.
Yeah, I think Prof did well because he needed to give a footing to know the actual structure and to get it clear as to where these recommendations and supervisions are coming from. But that particularly the position of the Committee on Application of Standards, CAS, was against the one for experts, which is purely independent. The other one operates at the plenary, whereas the other one operates independent and come with recommendations. Yeah, the simple thing, like what I have started saying, is that at the judicial point of view, we are looking at hard text laws and principles. When you look at the hard text laws, you are looking at the actual convention, actual protocols that you can put, like Convention C100, C1581. These are hard texts. But there are principles, labor standards that are based on principles. Those principles are driven like common law principles, not like statutory laws. So when you pick those principles and apply towards achieving the overall mandates of the ILO standards, which is to achieve social justice. A judge who is schooled in this, like I've recently been made a member of the alumni network member of the ILO, International Training Center. So when you do some of these programs with ILO, you come to the understanding that the essence of the judiciary or the adjudicator is to bring out that intention, and you search for it wherever it can be found. So if it's not found in the hard text laws, like ratified conventions, that does not mean they are not going to come up. And that's where you see these recommendations and even queries issued by committee of experts. Of course, they just published the 2025 report of the committee of experts just a few days ago, this February 2025. So that is available in the website of the ILO. You will see that they have done a lot of work to issue reports about those countries that they're having issues with some areas and who are bringing complaints. If you look at Nigeria, you see where NLC had, brought some complaints here and there, as well as other countries. A judge facing a judicial work like a National Industrial Court, looking at the impact of Section 254C1, H, and F. That one talking about application of international best practice and unfair labor practice. This is where the labor jurisprudence comes to play, because you have to be in search of what exactly is best practice in certain behaviors at workplace. Just recently, like last week, I did a judgment that involved a staff who was trained abroad with a service bond that will work for some years. And, if you can't stay with the organization, you pay the amount of the training. Then the young man left the office, the employee, without even notice, and sent them an email that, they should carry on and ask one of the youth corpers in the office to guide them very well on what is happening. If they have any problem, they can call him for assistance. The court considered that approach of resigning unfair labor practice under Section 254C1F, because that conduct should not lead to social justice. It is not, social justice is not about one party, like I said earlier. The employer also deserves justice as against the employee in workplace. So even the government itself deserves, like every justice is always a tripartite thing. Justice is not for one side, justice for the victim, justice for the person that is even the alleged person that did something wrong, then justice for the society. So everybody's watching. What should be the outcome of this kind of conduct? And the court took it upon itself to look at that conduct. Is that how to live an employment when you have been trained and you are now carrying the knowledge obtained from that training to go to a competitor to work, without regard to the contract you signed? So I first said that particular mode of resignation amounts to unfair labor practice on the part of the employer, given the provision of Section 254C1, C1H, and F. So the best standard can be obtained from even queries issued by committee of experts Our own president of the court, Honorable Justice B.B. Kaim, PhD, whoever, is a member of that noble body. And Nigeria takes an advantage that they have a sitting judge, the president of the court, who is also a member of the committee. So he guides all of us. Whatever is happening brings us update. And we follow to understand what is the best practice. So it's not about favoring one side or the other. The usual thing is that those records is about employee court. It's not true. In recent time, we've delivered several judgments that were against employees in favor of employers. I, for one, I have several. Last week alone, I had 3 judgments delivered on that the same area that affected interests of the employee, where the employee was trying to become harsher than is expected against the interests of the employer. So the employer had the day in court. So the queries and the principles obtained in the course of this supervision are also useful for adjudication, because you are in the field learning how these things are done. And the concept of best practice. What do you mean by best practice? Best practice is fishing out principles, searching out all of researching and finding out what is the trend, what is acceptable and what is not acceptable. And then it doesn't matter where it was gotten. That's why I say that's the difference between the principle-based adjudication laws and the statutory-based adjudication laws. When it comes to convention, actual hard text, yes, you can find them as hard text. You begin to debate whether it was ratified or whether it was domesticated. But when it comes to principles, it's like common law. We are drawing the principles and say this is what these standards is. And these standards are all domiciled within ILO, all the frameworks of ILO, including the Committee of Experts, including the Committee of Application of Standards. Any of those places that you can get the points required or the principle required for use in the courtroom adjudication, fine and good. They are all within the same principles of law. And it is not precluded whether it is a hard text law or a principle-based law. The important thing is that both soft and hard laws are used in adjudication, particularly where it is driven from the source of your own ground norm. So the section 254C1F and H of the Constitution of the Federal Republic of Nigeria, third alteration, is actually the basis of industrial code going into foreign to find out what happens in cooperative aptitude. Is it the position in other neighboring countries? Is that the position of the other members of ILO? How do you resolve this type of issue, particularly emerging disputes? Look at the issues of digital platform workers. Many of these workers were not in the legal regime of the existing laws. And if dispute arise from such situation, where are you going to do it? Lord Dennis said, if you have not done it before, what is the argument on the other side? Oh, you have not done it before. That is the only argument on the other side. Then you cannot stay and stand and wait until the law is changed before the whole rest of the world will now develop where you are standing, where you are standing. So I think that that's the role of judiciary, particularly National Industrial Court, that are brought from expertise point of view to look at it critically and know which of these recommendations, whether coming from report of the Committee of Experts or Committee of Application of Standards, or coming as a convention, or coming as a protocol, or coming as a recommendation. The important thing is that you are looking for what is the best standard, what is international best practice on this type of issue. Does this thing promote unfair labor practice? How do you curb unfair labor practice to promote social justice at workplace? Thank you.
Thank you, my Lord, for that very important clarification on the recourse to recommendations in the application of international best practices under the current jurisprudence of National Industrial Court. But I'm sure many people would want to ask whether that is actually a matter of, particularly when it is not ratified, whether it's a matter of law or a matter of fact that the parties have to prove what is international best practice. Is it actually the mandate of the court to go in search of international best practices when there is no ratification by Nigeria? Isn't this something that ordinarily the parties should establish by evidence placed before the court that this is the current best global practice on this particular issue? Can the court just go ahead and apply or ratify conventions as if they were law. I'm sure that will be the question in the lips of many practitioners, particularly in this
Can I just trash it
our
now, or you want to wait until later? Are you waiting later?
I can trash it now. I mean, just as
No,
an
because
addendum to this question.
you see, anybody asking that question still had not gone to the foundation where I was starting from. I said, if you look at section 254C2, that had said ratified convention, that hard text laws. Hard text, you can see these are where they are. And Nigeria had ratified or not ratified. That's when you are coming under that provision. If you are coming under section 254C1 and H and F, are you getting it? Talking about international best standard and unfair labor practice. This is where the rules are even saying that the person is considered a question of fact. But it's arguable whether such is even a question of fact. If a law is giving a direction on something, the court has said recently that all courts are bound to take judicial notice of laws and principles of laws. So the question is this a principle of law? That is on the other wing. So if the one that is on the principle of law, once a set of facts produces, what is the claimant or a party that's claiming in court is to make a fact. Once this fact is straight, it's for the law to, the court to bring out the principle of law applicable to the set of facts. You don't plead law. So it's an erroneous, it's a misconception for somebody to say that you will have to plead law, and therefore you are not proving law as a customary law. It is not, to my view, the correct approach, because you are pleading the state of your case. For instance, I gave you an example, like in this other case, this Joseph Osayede case. The Convention 3158 was not ratified in Nigeria, the termination of employment. But the question is, that principle established there, you are not quoting the convention as they are applying the convention. You are using the principle in that convention to come under the other one saying is best practice. Are you following the point? Now, what is best practice in the circumstance is that the circumstance deserves this way. That somebody who did not comply with a local law cannot terminate. Are you getting it? Because there's a DPR requirement that you must give consent, get consent of DPR before you sack. Then you are sacking in shell as a private organization, master servant. And then the issue is that you did not comply with this particular provision, which is a government policy. And that's the one is saying, if you don't give reason why you are terminating this person, and you did not comply with the local law that requires you to get consent, you just go home and feel that you have defeated both the government policy and the international standards set up for such regime. I said no. In the case of Osayede, has not been defeated on appeal. And until it is defeated, I will feel otherwise. For now, we need to defeat it, because that's the only opportunity that had come up to reconcile those side talks on it. Ratification is a condition when you want to use that provision of the Constitution, that convention. But when you want to use the principle behind the ratification, behind the convention, you don't need, because there's another provision, which is section 254C1, H and F. If you want to quote the one on convention, you must go under section 254C2. And if you are going under 2, it does not require you to domesticate under section 12. So this is all. I need just take a copy of this judgment and share to your colleagues. A lot of people have written articles and papers on it, and people have commented left, right, and center. I know the time the judgment was delivered, it was in the platform of Ellen and every other paper. I also saw some comment people made. So it is left for you people to look at it that way, because that judgment, as far as it's concerned in Nigeria, is the law. It has not been defeated on appeal. So what is it that we are talking about? Is industrial court not capable of bringing legal jurisprudence on an issue? If we don't have authority, we produce one. And that's why I was talking about Lord Denning. There was no authority to that effect, and it came before me. I did my best to bring out the point, and it's there. So if he is overturned on appeal, we return to where we were before. If it's not overturned, then it remains the law. Because you cannot allow foreign companies that come into the country to defeat local laws. It's also not best practice. It's also against social justice. What you cannot do in your own country, you come to another person's country to do it. That is the issue. Can we, as a court, not defend the laws of the nation? The requirement that you must get consent of the DPR before you sack a Nigerian workers. I said that, drawing my experience from petroleum law, that was a local content policy, trying to protect locals from exploitation. Are you getting it? So that was the background of that DPR guideline. Another case already was challenged by Shell, where my president, Honorable Justice delivered a judgment on that issue, also not defeated at the Court of Appeal. That judgment said DPR is extant law. That guideline is extant law, must be complied with, and it survived the BIA, Petroleum Industry Act. Now it came to me. I said, look, if you don't comply with this particular provision, you have not given even reason for you not to do so, you have not done best practice. And that best practice now is being challenged as unfair labor practice. And therefore, you are wrong. So that's it. So let us not masturbate our brain over this issue of whether it's ratified or not ratified. They are all pigeonholed. Issue of domestication is section 12, and it is general for general laws. Issue of ratification is section 254C2, which is for labor laws, including ILO conventions. The issue of unfair labor practice and international best practice, section 2541, C1, H, and F. These are different provisions of different laws, particularly the same constitution. The constitution cannot be contradicting itself, for goodness sake. It is the same constitution that made these three provisions. Thank you very much.
Thank you, my lord, for the clarification. I'm sure that at the point of questions, I'm sure we'll revisit this issue, because some people will say that there are other decisions, some decisions of the judges of the National Judicial Court that are also not in this line. You know, some have deviated from it, even with respect to the issue of termination in the oil and gas industry. But because of time, my lord, we'll revisit that question. Let me quickly now move to Professor Kalula on the question of examples of African countries that have been subject to scrutiny by these supervisory mechanisms, and how have they responded? Do we have instances where African countries have been subjected to, in ILO, various committees have sought to enforce compliance and implementation through this supervisory mechanism?
Thank you, Program Director. Yes, there have been many, including Nigeria, way back if you look. But there are 3 examples that I think are worth noting. The first one was South Africa. In 1966, at the height of apartheid, South Africa was compelled to withdraw from the ILO. And years later, they continued with the unacceptable practices, not only in terms of the workplace, but in the social area completely. So eventually, a complaint was brought against them. And this incidentally is also an example. I know one of the questions that you have later here addresses the issue of how unions have been able to contribute to compliance. So at that time, South Africa was not even a member of the ILO, because, and his lordship, I think, who recognize this, once conventions are ratified, unless they are denounced, and they are denounced many times, mostly because they are outdated, they are new ones, and occasionally countries to denounce them. When South Africa left, it did not denounce the conventions that was applicable to her. So under that word, the COSATU brought a complaint against it. And that led to the appointment of a commission of inquiry. That ironically, was the beginning of better things to come. Because at that time, I think South Africa had realized, I mean, there are theories about why it responded so positively to that, but obviously that pressure was one of them. So South Africa is a clear example. Another example that I was personally involved with in Africa is Zimbabwe. You referred to my profile there. One of the, I think the things that he started me off in the heart of ILO fraternity, so to speak, was as a member of the Commission of Inquiry that he inquired in the application and compliance with freedom of association in Zimbabwe. That was a commission that sat, I think, from 2008 to 2010. That's a clear example of that as another one, and that so I was, for my sins, I was a member of that commission of inquiry. Another one, which was which is an interesting and had more personal involvement is the issue of concerning Swaziland, Eswatini. You remember, I think, I'm sure your lordship has followed that. You remember the African Growth Opportunities Act, which President Trump now is in that, is about to dismantle. One of the provisions of that American Act was that a country would not pass muster of compliance unless it complied with ILO basic standards. And of course, on analysis, that was more about America than the ILO. So what happened in that case is that eventually, Eswatini, Swaziland as it was then, was continuously carpeted under the infamous, your lordship, you are probably aware of this, the infamous paragraph 3 of the rules of the Committee on the Application of Standards. They went in and out. And surprise, surprise, eventually the Americans suspended them from AGOA. Because the war AGOA, I said the war AGOA, what was an American consideration, self-interest, in the sense that when you take the Taiwan has a lot of factories in Lesotho, Swaziland, even in South Africa, Swaziland as it was. And they use the AGOA mechanism as a way of avoiding duty. And that's what happened. The Swaziland then persisted on doing this, and eventually the Americans suspended her from the benefits of AGOA. For my sins, I was asked to lead the delegation. I suppose the idea was to make Swaziland see errant ways, and it was an interesting mission because I was welcomed there with the red carpet. the Swaziland government then was so keen to comply and see me. In fact, my problem was convincing the American ambassador, and she was adamant that they would follow. So that's one way where you sort of intervene, and I've referred to the COSATU intervention, and many African countries have been so affected. But those 3 countries are clear examples of the kind of pressure, positive pressure in both cases, in all the 3 cases, because soon after that, Zimbabwe, after the inquiry, of course, it is detention and the ill treatment of trade unionists. It accepted a program of reform of this law and so forth. Yes. Thank you. I think I'll stop there for now.
Thank you, Professor Karula. We are almost running out of time. I will seek the indulgence of the panel to extend by a few minutes, just so that we can answer one or two more questions from the list that we have, and then we go into the questions from the audience, if that is okay with the panel.
Yes, no problem, program director. No problem, it's fine with me. I don't know about his
Thank you.
He's muted.
Thank you, Prof. Let's just move straight now to the complaint system. Beyond the supervision mechanism of the ILO, we also understand that
We've lost
there's a
you.
system where all stakeholders can make complaints. Can you hear me now?
Yes,
Can you hear me
I
now?
can hear you. Yeah.
Okay, so beyond the supervisory mechanism for the ILO, we also understand the complaints mechanism for the ILO allow both representation and complaints regarding non-compliance with ratified convention.
Yeah.
What are the key differences between these two mechanisms, the complaint system and the supervisory mechanism? I will just ask all the questions relating to this area so that you just address, and then we'll move to Honorable Justice Oboye. Are there notable cases where African trade unions or employer organizations have successfully used the representation process to push for labor reforms? Prof.
Do you want us to come back in? I'm ready to respond.
Please go ahead and respond,
Yeah,
and then
yes,
I'll just ask about the last question.
Definitely. I mean, you got to understand, and I think His Lordship, when he was addressing this issue of compliance, touched on it. Conventions are treaties. Unless a country has ratified them, in terms of as a matter of national sovereignty, it's not bound by a particular convention, but there are exceptions. And those exceptions are Conventions 87 on the freedom of association and Convention 98 on collective bargaining. And those conventions are fundamental. They are regarded to as applicable to all UN members, by the way. No, not least ILO members. Why? Because they are regarded as fundamental principles of the ILO constitution. So on taking up membership of the ILO, you are bound. So if you take the Committee on Freedom of Association, we consider complaints from all countries. In fact, our major customer is China. And China has not ratified 87 or 98. And the other countries, the Americans also haven't. So the difference between complaints and you refer to trade unions, yeah, the complaints can be brought about by either trade unions, workers' side, or employers. And in fact, the interesting thing is that although most of the complaints are from workers, in recent time, you have had, for instance, one of the most protected complaints now against Venezuela has been brought by employers. But there are also representations within the mechanism of cars that are brought through the system. And unions, you asked, in terms of their influence and pressure, they are key to that because most of the complaints originate from unions. the unions have got the status to bring complaints, and so have employers' organizations. Another group that has got status to do that are international organizations, NGOs that have got status at the ILO. And in fact, when you take Cuba, China, those complaints are not brought by unions. They are brought by either the International Confederations of Trade Unions or Amnesty International or other that have got standing of bringing those complaints. But your point in terms of your question is unions, yes, they have participated in that through bringing pressure and so forth. Yeah. And if you take the issue of the procedure of the Committee on Freedom of Association, that's the way it originates, that, the committee is only seized of complaints if they have been brought by one of those social partners. Gone is the day when, and this was the unique thing His Lordship mentioned, that the ILO was established and structured with this unique tripartite structure, which obliges governments to consult the social partners in terms of social policy. And of course, labor law is a key component of that. That system, the Committee on Freedom of Association, was not always there. It came about, it was established in 1951. It came about to provide exactly that kind of space for governments to be taken to account. And I always say that one of my dubious claims to fame is that although the committee was established in 1951, it did not start its work until 1952. That's when I was born. So I'm grown up enough to chair it. So that's the way it works, Program Director. Yeah.
Thank you, Professor Kalula. Because of the time, I will just ask the last question and I'll pose it to my Lord Honorable Justice Mwanya. One question from the list of questions, and then one question from the audience, which is the only question I can see from the chat room here. The question is, my Lord, how can African governments, looking at the Nigerian experience so far that you have spoken about, how can other African governments, employers, and workers collaborate to improve ILO convention implementation and compliance? And the question from the audience to my Lord is that why are there conflicting decisions from the NIC on this issue of termination with or without reason? My Lord has spoken about the fact that this issue of termination without reason is a fallout from international best practices, which the NIC has been empowered by the Constitution to apply. But there are conflicting decisions. In some cases, judges of the National Industrial Court have heard that they seem to have discounted the underlying international labor standards issue as it relates to termination without employment. So currently, there appears to be so many complete decisions, even from the Court of Appeal up to the Supreme Court. And lawyers are having challenges advising their clients on this issue. It would be I mean, we all will be happy if my Lord can, give a clarification in this regard. And that will wrap up the webinar for today.
Which one do you want me to say about? Is it the question or the answer? The one on conflicting judgments or how can other African countries? I don't know.
I think my lord should answer how can African governments, employers, and workers collaborate to improve ILO convention implementation and compliance. And then
That
my
one
lord
is
can then
simple.
move to the question from there.
That one is simple. It's diplomatic relationship. If they enhance diplomatic relationship, they will all influence each other. That's what diplomacy does in international law. You collaborate and start relating and even start competing on best practice model. You did this here, you did here, so every other person will comply. Moreover, ILO is also subject to jurisdiction of ICJ. So those who don't do well at international level, some people can be bold enough to take them to ICJ through the ILO. So, but I think that the most important part is collaboration in diplomacy. If you feel that somebody is doing well and they can collaborate, because that's where labor migration will not be effective if you don't collaborate, because that is what will enhance standards. It's not that the way workers are treated in Nigeria will be different from that of Cotonou or that of Ghana or Cameroon or Algeria. So if you have this uniform standard or best practice, and that's what they're preaching about, best practice. Once they imbibe that attitude of relationship and sharing and comparing notes and uniform capacity building, it will be better off for everybody. Then on the conflicting judgment, I think it's prone to happen, so it's not new in Nigerian legal system. But I think there's always this problem of what we call conflicting judgment. And at a larger scale, I think there's a problem in that area across board. If a judgment is existing on a subject matter, and then a new judgment is to come, and a new judgment did not take cognizance of existing one, for whatever reason, what do we call that? It's just direct collision. So if you want to overrule or say something, particularly at the court of coordinate jurisdiction, is even worse, because until the judicial intervention at the appellate level, everyone is standing on his own. It's unlike the appellate court that has some rules about which one come last and whether the other one has overruled the other president or whether the new president has emerged. It does not occur like that in jurisprudence when you look at the courts of coordinate jurisdiction. And that's where the problem is. Courts of coordinate jurisdiction, like our own court, that even have a platform, that have a system where we compare notes and everything is a platform. I don't see the reason why we should also be mad in that plague of conflicting judgment. So, because conflicting judgment is not good. It misdirects the practitioners will not know what law to rely on. The clients cannot be properly advised. The society is not even sure what their laws are on some issues, because the courts, what comes from the court is actually lawmaking, no matter how you talk about it. If you look at the American reality, or if you see it that way, it's what the court actually does that brings out the law. So that should be very carefully done. I'm not holding brief for anybody, but I think that a major issue like this requires harmonized position. It's not going into self-defeating. If, for instance, industrial court uniform, say, oh, this is international conventions, we are also part of government, we want to enforce. Nigeria should look at the ones that they don't want and denounce them. There's also a process of entering into international treaties. There's also a process of exiting those treaties. If we review it and find that these ones are not good for you, or you are not matured enough to get it, nobody forces you to enter into any convention or international treaties. But if you do it for diplomatic reason, or whatever reason done, and then you applauded an international scene, you come back here and then it comes to court of law, and judges are now shying away from implementing it. That's not good enough. What should be is that we should agree on a uniform standard. If we want to disagree that convention should not be applicable according to section 254C1, C2, which is very express and written very in black and white. if we say we cannot implement that provision of the Constitution, we should agree on that. But it should not be that one judge will say, oh, this is the way to go. This is what I see here. This is provision say this. Another will not say that or not agree with it or not even remember that there's a judgment already on that subject matter. We compare notes a lot. I'm surprised that this issue is coming up at the circle. We really compare notes seriously. There's hardly any judgment that's come. If you read that judgment in that one I was referring to, that Joseph Osaida against Share, you will see a lot of our colleague judgment that we reviewed there. A lot of judgments that came up on DPR were all reviewed there. So if you review them and find a better reason not to follow your colleague, that's better approach. But not to bring them to the fore and just come as if you are throwing a fresh stone inside the sea. It's not good. I don't see that. I've not seen it. So I don't know when people say they complain about this, complain about that. Until they start to bring practical examples and referencing one or the other, then we'll be making some points. But some people just say, oh, they are completing judgment. What really amounts to completing judgment? Is it a judgment that completely opposes the other one without referring to what the one is existing, or the judgment that is on its own? I think what they consider as a complete judgment is the judgment that's on its own. A judgment that did not give reference to existing precedents. I think that's what should be seen as conflicting judgment. And that one should not even have a stand. If a judgment does not take care of or refer to the ones existing by way of precedent or comment on some issue, then it's on its own. It shouldn't be accorded such something that will now be considered a threat to existing accepted principle, particularly at courts of coordinate jurisdiction. That area, you don't need to have conflicting judgment at courts of coordinate jurisdiction. It's the other side that you see, okay, there's a judgment, then because they are bound by precedent, so you need to know what the position is as a trial court. So you look at that one, and if there's something, no, so this is the latest, or this is what, so you read their own judgment, that's it. But at the other level of coordinate jurisdiction, I don't see why coordinate. So if there's any, it should make it available to us, and we'll look at it critically, and we'll come up with a harmonized position. But to just say that the completing judgment without looking at the rationale behind the new judgment is not a completing judgment in the sense. If a judgment has, maybe a judgment was delivered with a pen courier, a new one came and said, oh, if this one had considered so and so issue, he would not have arrived at this decision. It's not a completing judgment. It's not a completing judgment because it has addressed what the other judgments have said and then come up with a distinguishing it to show, oh, this one departed on the basis of this. That's not conflicting. So thank you very much.
Thank you a lot for that very exciting explanation on the issue of conflicting judgments. At this point, considering the time, I want to thank my Lord Honorable Justice Boya for the time, as well as Professor Evans Kalula. I will now hand over to Mr. Shehu to wrap up the program.
Thank you very much to the panel. Thank you, Mr. Moderator, Mr. Program Director. I think we're really grateful. I think the formal vote of thanks will be given by Mr. Akolade, Jamiu Akolade of Elan. Thank you very much. Jamiu, can you say the vote of thanks and let's everybody go home for the evening? Jamiu, are you still available? Okay, well, I guess I will just give the vote of thanks. And I mean, we are grateful. All the audience participants have learned quite a lot. There is things that get said in forum like this that don't get said in formal judgments and in formal presentations that we learn a lot from. And so we are really grateful. The personal experiences shared, all of that, we are grateful. We thank My Lord Justice Ogwanya, we thank Professor Kadula for taking from your evening after a hard week and coming to still spend time to share knowledge and experiences with us. We are grateful. And we thank everybody for attending, wishing everybody a restful evening and a good weekend ahead. Bye-bye, everyone. Thank you.
Thank you very much. Bye-bye. Your Lordship, I hope we meet soon.
Yes,
one
I
of
think
these days.
we need to meet.
Yes,
Thank
yes,
you.
thank you.
Yes,
But
please.
continue
We
with
need to meet.
the remarkable work. Yeah, thank you.
Thank you very much. I really
Thank you.
enjoyed your.
Okay, bye-bye. Yeah, bye.
Yeah, thank you. Bye bye. Yes.